That's not what his lawsuit's about. His lawsuit it goes over about a 2-year period of time where she's repeatedly defaming him on the internet, Your Honor. And
Page 2, case A 862-259, Shannon Ruth versus Nickolas Carter.
Good morning, Your Honor. John Kawai for Plaintiff Ashley Repp.
Good morning.
Morning, Judge. Dale Hayes on behalf of Nick Carter.
Good morning.
Good morning, Your Honor. Mark Boscovich on behalf of Shannon Ruth.
Good morning. Okay, so you may have heard I do have a limited amount of time today, which unfortunately is going to be the case pretty much every hearing date for the next few weeks. But I've reviewed AR's special motion to dismiss the counterclaim as an anti-S.L.A.P.P. motion, essentially, the opposition, the reply, the pleadings. Some questions I'd like to hear about, which, may be in the briefs, and I did review them more than one time, but I may have missed things. So what, if anything, was Florida's statutory sexual assault law circa 2003? What evidence do I have of plaintiff AR's birth date? Can a moving party not submit evidence with the motion and simply rely, on an answer / counterclaim in the allegations pleaded therein by the other side? And is there a police report? Let's see, because page 5 of the motion says AR reported in good faith in or about 2004, cites to Carter reply exhibit A, page 1 through 15. I wasn't sure what that citation was, so I don't know, is there a police report that's referencing, or what, if any evidence there is on that? I'm at least inclined to grant in part, if not in whole, the motion. But you've each got 10 minutes of time in total. So, Mr. Kawai, go ahead.
Thank you so much, Your Honor. And I understand the court is busy, so I will be as expeditious as possible.
Okay.
This is a somewhat unique motion in the sense that the facts sufficient to grant the motion are admitted. So essentially what we have is statements in the answer and counterclaim admitting that the sexual conduct took place between Mr. Carter and Ms. Repp at a time when she was not of age, specifically 15 years old. Now, in terms of the evidentiary burden, these are treated as judicial admissions. Admissions in the pleadings are treated basically as judicial admissions, and they're binding on the party who makes them, and therefore no evidence is necessary to support them. It's basically a waiver of proof of a fact by conceding its truth. So that's what we have in this case, and it's a little bit different in that sense. If we took the admissions that are made by Mr. Carter in the pleadings and in his own declaration, and we took it back in time to Florida at the relevant time period, it would essentially be an admission of guilt to what was the statutory rape law at the time. And I did make a note to myself of Florida statutes annotated 794.021 and 800.04. I might be able to see if there was another statute that applies. I know that we made we spent a lot of time on how ignorance is, not a defense to the subject crime. I did want to clear up one thing. The court did not refer to it, but there was a discussion in defense's opposition about a Nevada statute, and there is a separate statute that's labeled, they're both sexual abuse, but there's one that's labeled sexual assault, and that refers to people 14 and under. There's another one called statutory seduction, which literally refers to sex with somebody who is 14 or 15 years of age by somebody who is at least 4 years older. There is a police report, Your Honor. I don't have the specific site in the appendix, but there wasn't, in fact, a contemporaneous police report. And unless there are any further specific questions, I will cut myself off.
Let's see. No, you'll have a rebuttal. Okay, Mr. Hayes.
Yes, thank you, Judge. Your Honor, before I address the questions, the inquiries you made, I want to point out the fact that, we're kind of we need to put some context to this proceeding. This is an anti-S.L.A.P.P. hearing, and the whole point of Nevada's anti-S.L.A.P.P. laws, and really anti-S.L.A.P.P. laws across the country, is to protect litigants from frivolous lawsuits, baseless, groundless lawsuits. And I submit to you, Your Honor, just based on the history of this case and what's in front of you, that's not what we have here. We don't have a baseless lawsuit. Ms. Carter has articulated a very detailed, lengthy counterclaim. He alleged, a very detailed conspiracy in that counterclaim, not just supported by circumstantial evidence, Your Honor, which, as you know, is typically the only evidence submitted in connection with claims like this, defamation, civil conspiracy, but direct evidence. We have a participant in the conspiracy that's testified, yeah, these people were colluding to scheme to defame Mr. Carter so they could extort him. And he supplemented his affidavit in connection with this proceeding to indicate that Ms. Repp was, quote unquote, on board with the scam, Your Honor. And we have tens and tens of affidavits of testimony, hundreds of pages of social media posts evidencing the collusion. And more importantly, Your Honor, the admissions of the actual co-conspirators. We have Shannon Ruth admitting over and over again for almost a year, Nick Carter didn't rape me. We have Ashley Repp. You just asked about the police report, Your Honor. The reason why that's so crucial is she goes on and on in the police report, indicating that none of the sexual experiences she had at Marathon were anything but consensual. And particularly with Mr. Carter, and the law enforcement officers and the prosecutors that were investigating her repeatedly commented on her deception, on her admissions, and her overall conduct in determining whether or not to charge her. Now, Your Honor, you were asking about the Florida statute, and and obviously I didn't like to hear your inclination and where you're going with this, but that's why I want to take the time to educate you. Any prosecutor's office, Your Honor, it's black letter law, and I have a cite to you from the U.S. Supreme Court in Goodwin. It's also the law in Nevada, and it's also the law in Florida, by the way, that prosecutor's office have the absolute discretion to decide who to charge and what to charge with. Unless we're talking about issues like racial discrimination or something, you can't touch their discretion. And law enforcement and the prosecutor's office in Florida at the time not only decided, after a protracted investigation, Your Honor, they spoke with numerous individuals, mind you, they not only decided not to charge Mr. Carter with this offense, but they admonished Ms. Repp, that you're lucky you don't get charged in connection with your behavior in these circumstances. And the reason why this is so relevant, Your Honor, is what Ms. Repp is trying to do with that. Really, in my mind, Your Honor, you call it a failed investigation because it didn't result in any charges, indictments. It certainly didn't result in any adjudications or convictions. They're trying to assert, Your Honor, res judicata or collateral estoppel in the sense that, hey, look, because there was a stat rape offense in Florida 20 years ago, he's a stop, and the consent factor is going to be dispositively established in this Nevada lawsuit. And that's so, you have to think of it in terms of that, Your Honor. There's probably a reason why counsel's not using words like collateral estoppel or res judicata. And the reason being is the standard's so high. And what do you have to have, Your Honor, in the prior proceeding? You have to have both parties involved. You have to have an adjudication, a final adjudication on the merits. I mean, for him to say this happened in Florida and now he's barred from asserting some kind of consent in Nevada is absolutely absurd. It flies in the face of the facts, Judge, and there's no law that supports him. That's why he didn't cite to any law. And I invite you to ask him that on rebuttal, because I'm not going to have a chance to respond to him. There's no case law that supports the notion that a civil party will be barred from asserting somebody's mental capacity because of a criminal statute 20 years ago that the civil litigant happened to have been investigated under, not charged under, not adjudicated under, Your Honor, but simply investigated under.
No, I mean, that's not their argument. So I'm
in essence, it is though, Judge. They're trying to say they're trying to use the Florida statute to resolve the consent issue, Your Honor. And if you don't like the collateral estoppel res judicata analogy, Your Honor, I cited the Honia case from Nevada. This is a Nevada Supreme Court case. It's exactly on point. In the Honia case, a defendant was charged with sexually assaulting a young girl from the time she was 11 till the time she was 15. Rather than charging the young girl under the rape statute, the prosecutor decided to charge her under the standard rape statute. Well, the standard rape statute in Nevada allows 15-year-olds to consent, Your Honor, whereas the rape statute does not. So when it came time to get to prosecute the offenses that occurred when the victim was 15 years of age and older, the defense asserted consent as a defense under the standard rape statute, right? Well, then the prosecutor in response did exactly what Ms. Repp is trying to do here.
Tell me how Nevada law would apply to a determination to the alleged facts that happened, 2 decades ago in Florida.
It's just more relevant, Your Honor. You're absolutely right, but you got to understand something. You just hit the nail on the head. Nothing was adjudicated in Florida. In fact, the result of that investigation was in favor of Mr. Carter. Not only did they decide not to charge him, Your Honor, they admonished Ms. Repp. They got into her deceit. They got into the fact that she admitted.
Didn't you and your opposition say, hey, we aren't even pursuing claims under the police report? We're pursuing claims really based on whether you call them tweets or social media posts that plaintiff AR made.
Well, sure, Judge, but this is an anti-S.L.A.P.P. proceeding, right? So we're talking about communications. She's alleging truth. We're saying defamation, and she's saying, okay, no, it's true because you admitted to having to committing stat rape. And no, we didn't. Mr. Carter admitting to having consensual sex with a woman he reasonably believed to be 18 years of age. And Your Honor, you actually made another good point when you opened up and you asked about any evidence of her age. There's absolutely, all we know is that she lied about her age as far as the evidentiary record goes. There's no evidence. She didn't even submit a declaration saying how old she was in Florida, Your Honor, and that's dispositive of the issue. She can't come into you in an anti-S.L.A.P.P. proceeding where her very burden is preponderance of the evidence, which, Your Honor, by implication involves a weighing of the evidence. The statute specifically talks about her producing evidence. And instead, she sits back and wants to rely on pleadings, which is essentially legal arguments, Your Honor, from my client, and twist his quote unquote admissions to mean something they don't mean. And there was never a proceeding in Florida, Your Honor, that they can hang their hat on and say this has already been established. It not only was it not established, again, that investigation concluded in a fashion that weighed in favor of Mr. Carter, Your Honor. And I think that's crucial here and dispositive of these issues. I mean, if you do nothing else, Your Honor, please take this under advisement and read the police report. I mean, it's riddled. This woman acknowledged everything she.
One question I had is, there's more than one police report. And so, for example, you're talking about police report. I'm not sure which one you're referring to. I know you attached at least one, if not more than one. Like I said, the motion talks about, one from 2004. I didn't see that one.
There's only one, Your Honor, governing Ms. Repp, at least to our knowledge, and it's a Marathon Florida report. It is an exhibit to my appendix. I'm trying to find it really quick for you. I can certainly contact your department after the calendar if I can't find it skimming through it. But Your Honor, again, I can't emphasize enough, especially because it seems like you're not familiar with that specific report. The investigators, ultimately concluded their investigation erring on the side of Mr. Carter, and that just goes by the wayside with Ms. Repp in these proceedings. She just continues and comes in ad nauseum. Her mantra is he admitted to rape. He admitted to rape. He admitted to rape. That's complete falsehood, Your Honor. And getting back to, I don't, does Your Honor want to hear anything else about the police report, Judge? The law is clear with respect to her not submitting any evidence, that she's not allowed to do that. The only circumstances in which she'd be not allowed to do that, Your Honor, would be in a scenario where there wasn't contradicting evidence in the record. And the case law that I cited to counsel, misunderstands it and argues that I argue he has to submit a declaration. I didn't say he had to submit a declaration. What I was saying to him was the case law is clear that when there's contradictory evidence in the record, which in this case you have, Judge, you have this litigant's admissions, sworn admissions, that she was not sexually assaulted. You have the friends of hers who testified they were communicating with her while she was in Marathon, and that she was excitedly and willingly and voluntarily engaging in sexual acts and was seeking Mr. Carter out to do this, and that they do not believe she was sexually assaulted in the slightest. You have testimony from recipient witnesses, Your Honor, that were in Marathon that talked about her showing up and showing an ID, that she was 18 years of age, that talked about the fact that the entire time she was there, she expressed nothing but joy and excitement to be there, and expressed no signs of being distressed, Your Honor. Just all of the evidence that's been submitted in this case, Your Honor, clearly points to this woman not being assaulted, including her own admissions, Judge. And for Ms. Repp to come to this proceeding where she has the threshold burden, if she doesn't satisfy her burden, Your Honor, we don't even get to the Florida arguments. We don't even get to the actual malice issues. We don't get to the consent issue because the statute's clear. If she doesn't satisfy her burden, the inquiry ends and the hearing's over. And that's what should happen here. Not only does she not cite any evidence or bring any evidence into play, Your Honor, she fails to even identify and address the communications that are at issue in Mr. Carter's counterclaim. Instead, she talks about, and I pointed this out in my opposition, Your Honor, she talks about things she said to police in 2004 and things she said in her lawsuit in front of you. That's not what his lawsuit's about. His lawsuit it goes over about a 2-year period of time where she's repeatedly defaming him on the internet, Your Honor. And one of the important factors about her defamatory statements, Judge, is not just that she's not saying he may or may not have committed statutory rape 20 years ago, Judge. She's not saying that. She's saying he's a rapist, he's a serial rapist, that he's a predator, that he's raped other women. These things are not only all false, she's submitted absolutely zero evidence. Even if you buy Mr. Kawai's arguments that he can rely on, an admission to essentially getting tricked into having sex with somebody. It's called rape by fraud. There's some treatises that I cited to in my brief, Your Honor. She can't, get away with this, Judge. And I want to get into the other arguments, Your Honor, but I feel like I want to address your point. So I'd rather give you time to ask questions if you.
I don't have anything further. Let's hear some rebuttal.
Yes, Your Honor. Judicial admissions are evidence. If you need a case cite, there is, Whittlesey Blue Cab versus McIntosh, a Supreme Court of Nevada case, 86 Nevada 609. That actually involved a case where pleadings were deemed to be admissions in subsequent proceedings, so not even the same proceeding. The same logic obviously applies to admissions within the present proceeding. The specific statute that would have been violated had Mr. Carter's admissions been made at the time of a criminal inquiry in the state of Florida is Florida statute 794.011 for the court's reference. Again, there were a lot of things that were attached to defendant's opposition that were frankly not relevant. Things about, feeling honored about the sexual assault, things like that. I mean, that when we logged into the proceeding today, it said no personal attacks, and I'd like that principle to be applied to my client as well. What's relevant for the purposes of determination today on whether Ms. Repp made true statements in light of the admissions here, such that she should not be sued for defamation, that can be ruled on and this motion can be granted. Thank you.
Thank you. So I'm going to order additional supplemental briefing. Like I said, I read through this stuff more than one time and had questions, coming in. Some of those have been addressed, some, have, not necessarily been addressed. And so we're gonna do, and, in part, I feel for the attorneys, because I'm gonna have you all do more briefing, but I want to get this right. And the motion itself fairly bare bones. And so, it's not really appropriate to file a bare bones motion, then put everything in a reply or bring new stuff up even at the hearing. So I'll tell you the issues that I would like to hear about or be addressed in the supplemental briefing. I'm not going to limit either side to these issues, but hopefully you're smart attorneys, you'll know that you should probably focus on what I'd like to hear. So I need Florida law circa 2003 in terms of, whether it's, and I'm just kind of paraphrasing because this is why I need it. I don't know the exact terms. And so Florida law circa 2003 that in particular AR claims, was in place that would support her characterization of, truth is an absolute defense. Clearly, to be clear, truth is an absolute defense to defamation. But I need Florida law that was in place at that time that would support, hey, because she was underage, even consensual sex would be, sexual assault or statutory seduction or statutory rape, or, again, I'm struggling because I don't have the statutes in front of me. So there's that. I need a copy. Again, I asked, I didn't see in my review and still was not specifically pointed out to me. A copy of this 2003, 2004 police report referenced in the motion. Maybe I have it, but I specifically asked somebody to point it out to me. Nobody did that. I need law, an argument on whether statements in a pleading such as a counterclaim here are judicial admissions. And specifically, I need exact citation in the counterclaim that plaintiff AR is relying on as a judicial admission. If plaintiff wants to submit actual declaration in support, that's fine. I don't have a declaration from plaintiff, so if you want to stand on that, that's okay. If you want to supplement with the declaration, that's okay. Because if claims in a counterclaim are not judicial admissions, then there seems to be a lack of evidence in terms of birth date, perhaps other things. If there's any particular law more on the point of an anti-S.L.A.P.P. arena, whether statutory quote unquote rape suffices to be truth as to call somebody a rapist, as AR has called Mr. Carter. Happy to hear about that. And then, of course, after plaintiff files a supplement, then we'll have a supplemental opposition, supplemental reply. So how much time do you want to file supplement to the motion, Mr. Kawai?
Some of this is already in the work, is ready to go, Your Honor, but I would request at least 1 week.
Oh, sure. I mean, if you want 2 weeks, that's fine, or 1 week's fine. Either one's fine.
You know, I would honestly go around the court's convenience because the court will be engaged in trial for a few weeks. So if the hearing, for example, would be in any further hearing would be in 3 weeks' time, then, take roughly half of that
Okay.
time and then half of the remaining time for the rebuttal, perhaps.
Okay, so let's do, so today is, what's today? June 4th. Yeah, so why don't you do your supplement on June 14? So that's Friday, that's a week and a half. Mr. Hayes, how much time do you want for a supplemental opposition?
Judge, I'd like to have 2 weeks if it's possible.
Yeah, that's what I was thinking. So 2 weeks, that would be June 28. Mr. Kawai, how much time do you want for a supplemental reply?
See, this will be at the end of June. Just a week should be fine, Your Honor.
Okay, that would be July 5th. Does that work okay for you?
If I can look at the holiday calendar.
Yeah, that's what I'm asking. Make sure you're
If we could make it July 8th, Your Honor.
yeah, that's fine. So July 8th supplemental reply. Let's bring you back for hearing. Do we have July 17? Oh, I'm sorry. Geez, I'm still going back. So July 18th.
July 18th at 9 a.m.
Your Honor, just by way of how you've been asking for the site to the Marathon Police Report throughout the hearing, it's in our appendix, date stamped 54 through 68. So I couldn't, my brief's rather lengthy, so it's difficult to. You got it?
Yeah, thank you very much.
No problem.
But, yeah, what, do you have an exhibit number?
Because we did an appendix, I don't have the index in front of me, Your Honor. I just know.
Number of exhibit, it's exhibit 10.
Okay, thank you.
Oh, man. Okay, so maybe, okay, yeah, it's there. Okay, so I have that. I apologize. I missed that. I think what threw me off is I saw 2020, but that was just a printed on date. Okay. So I do have that, so that's good. All right, I'll see you back in a month and a half.
Thanks, Judge.
Thank you, Your Honor. Thanks, everybody.
Thanks, Sean.